Welcome. Father, I come before you, Lord. I adore you. I respect you, King of Kings, Lord of Lords. Thank you, God, for giving me yet another opportunity to do this recording. Professional Ethics and Practice November 2024. Past paper. I don't take it for granted. Give me stamina, wisdom, knowledge to be able to do this recording. Let the devices work, the internet, the Zoom, my audibility. I pray all this believing in Jesus Christ, my Lord and Savior. Amen. So welcome to this Professional Ethics, November 2024. This was the paper that was filled so much by students in the exams in November that came out in December 2024. I'm doing this recording one day to the April 2025 exams. Today is 9th April 2025. It was prudent for me to do this. I want to confess that this paper was very hard, even in researching, and they brought new questions, very many new questions that have not been tested in the past. Remember, I usually advise that looking at the past paper is usually an advantage, but for this paper, they brought a lot of new questions, and now I understand why the results were the way they were. So welcome to this. Listen, take notes, and be able to be ready for exams. And subscribe to my channel, and God is going to bless you. So I'm going to read question 1. You're an advocate of High Court and have been approached with a recruitive, though high contributed brief on some Lebanese clients through your classmate Joseph. In the brief, you have been offered a handshake of 1,000 even before the assignment is undertaken. Underline that. While the clients are willing to sign documents, they are not willing to meet you or see you. Underline that. They have indicated to Mr. Joseph that they are illegally working in Kenya and have no plans to live in the house as they have been staying 2 years out of fear that they'll be identified by law enforcement agents and arrested. Underline that. Joseph has informed you that if you take up the brief, you have to create a notary stamps to use so that it can be shown that they signed the relevant affidavits from Singapore. Underline that. That is an ethical practice issue. They also have another strange demand. They want to delay their matter so that the judgment in another country against them can be enforced fast. That way, they will be declared bankrupt and be unable to meet their financial obligations. Underline that. First, they approach the judge privately. They want you to approach the judge privately to see if they can help sort out the issue. Underline that. If that fails or is not feasible, they want you to file an application for the case of the judge who is handling the case in Kenya. Underline that. Alleging that she had been bribed to prompt her not to proceed with the case on the date it's scheduled for her hearing of final submission. Underline that. In light of these facts, examine the situation under which advocate's client relationship arises and whether you could consider advocate relationship exists between yourself and Lebanese clients. 4 marks. So those are 4 points. You give 4 marks. 4 points, 4 marks. This is the first time the question is being tested. And this is the answer. Situation under which advocates can't arise. Request for legal services. An advocate-client relationship typically begins when a client requests legal services or representation. Acceptance of this request establishes the relationship. Agreement to represent. The advocate must agree to represent the client explicitly, either through a formal agreement, correspondence, or contractual intent to take up the matter. Payment of fees. Payment is often a strong indicator of the relationship, as implies the clients have retained the advocate services. D. Confidential information. Sharing confidential information by client to seek legal advice strengthens the relationship, as the advocate has a duty of confidentiality once engaged. E. Professional conduct. The relationship is governed by ethical considerations such as loyalty and competence and confidentiality. Examination of the case now. Now you apply that. Request and payment. The Lebanese client have approached you through Mr. Joseph and offered a signal payment of 1,000 profit. However, this offer seems to be contingent upon an ethical and legal demand, such as creating a notary stamp and approaching a judge privately. No direct engagement. The clients are unwilling to meet or see you, which complicates the establishment of trust and transparency that is essential for an advocate-client relationship. Illegal activities. They can't have disclosed their illegal status in Kenya and are requesting actions that would clear violate legal ethical standards, including fabricating documents and delaying their case from ulterior motives. Ethical duties. Advocates are bound by professional ethics, including duty to hold the rule of law, avoid fraudulent practice, and refrain from conflict of interest. Accepting this would contravene these obligations. Conclusion. Based on these facts, it would be improper to consider an advocate-client relationship as validly existing between yourself and the Lebanese clients, in quote. While payment have been offered and requests for legal services have been made, their demands are unethical and illegal, eliminating any potential engagement untenable as the Advocates Act and SOPEC. Furthermore, accepting this brief will expose you to legal and reputational risk. Mhm. 1B. As an advocate who believes in conducting ethical practice, what alternative approach would you use to help them achieve their objectives? 2 marks, you give 2 points. In point form, so the keyword is alternative. First time the question is being tested since 2008. So what are some of the alternatives? So encourage voluntary compliance with the law. Inform the clients of the risk of associated with illegal status in Kenya, encouraging them to regularize the immigration status through lawful channels. This step would involve applying the residence permits or necessary documentation. Advise them to comply with legal obligation in good faith rather than resorting to deceptive practices. Seeking critical, point number 2, seeking credible legal advice instead of attempting to delay proceedings. Advise clients to engage in proper legal representation to present their case within judicial system. Suggest that they resolve any financial dispute or obligation transparently, whether through settlements, legal defenses, or bankruptcy application as permitted by the law. Point number 3, avoid falsification of documents. Reiterate your refusal to create or facilitate falsified notary stamp signature of affidavits. Set the importance of honest and valid documentation in legal proceedings. 4, uphold judicial integrity. Categorically refuse any request to privately approach the judge or file frivolous application for recusal, which undermine the integrity of judiciary and could lead to severe legal repercussion. Instead, they advise the client on appropriate and lawful steps to challenge any perceived bias or impropriety through existing legal procedures. 3, discuss the duties you have as an advocate owes to a client. 4 marks, that is 1C. So this question is tested many times in the past. The duties that an advocate owes to court. Point number one, 4 marks, you give 4 points, explaining them. Duty of candor and honesty. Advocates an obligation to act with the utmost honesty and refrain from misleading the court. You must never knowingly submit false evidence, fabricate documents, or represent facts to the courts. Duty to uphold justice and rule of law. As an officer of the court, Section 55 of the Advocates Act is primary responsibility is to ensure justice is served and the rule of law is upheld. Deliberately delaying the legal process to further grants ulterior motives such as avoiding financial obligation through bankruptcy would undermine judicial process and violate this duty. Duty to maintain integrity of judicial process. Advocates must engage in practices that bring the judicial process into disrepute. Approaching the judge privately to sort out in court the case would amount to interference with judicial independence and could expose you to disciplinary action and legal sanction. Point number four, duty of fairness. Advocates are required to act fairly to all parties involved in the case, including the courts and the opposing parties. Filing baseless application for recusal of a judge on fabricated allegation of bias would breach this duty. Explain what is professional responsibility is. That is 1D. Highlight the aspect of the above scenario that will compromise your professional responsibility towards your client. 4 marks, you give 4 points. So professional responsibility, you define it, refers to the legal, ethical, and moral duties that an advocate owe to their clients, the court, the public, and their profession. It encompasses the obligation to act with integrity, uphold the rule of law, maintain client confidentiality, act in the client's best interest within lawful boundaries, and adhere to ethical standards set out by the legal profession. Aspects in the scenario that could compromise professional responsibility. So now answering the second part of the question, number A, compensating fraudulent acts. The council are requesting you to create a falsified notary stamp and fabricate affidavit which constitute fraud. Engage in such conduct violates your duty to uphold honesty and integrity in your practice. B, undermining judicial independence. Approaching the judge privately to sort out the issue interferes with judicial independence and breaches your duty to the respect and protect the integrity of the court. C, abuse of the process. Intentionally delaying the case to allow the enforcement of foreign judgment undermines the administration of justice and compromises your professional obligation to uphold the rule of law. D, or point number 4, conflict between ethical conduct and client demands. The client's demands conflict with your ethical duty to act lawfully. Acting on these demands would compromise your professional responsibility to provide representation within the boundaries of law. So again, this question was the first time it was tested. E1E, would the claim for the judge has been bribed be a valid ground for judicial recusal, exploiting certain relevant case law? So I realized that this paper asks students a lot on case laws. So yeah, that is one of the things that made this paper to be difficult. So 6 marks, you give 6 points, and also you quote a case law. Questions on the case of judge, that's tested question 2A, November 2013. Question on ethical conduct of a judge, that's tested question 1B, March 2023. So this question is repeated indirectly from past papers. 6 marks, you give 6 points. So this was the answer. Taking a bribe by a state officer, remember a judge is a state officer, is both criminal offense and in context of a judge, he can be removed from office based on breach of Article 10, 73, 75, 75(1), 161, and 232 of the Constitution, and Judicial Service Code of Conduct and Ethics Regulation 2020. Code of Conduct. That is point number one. The claim that a judge has been bribed indeed a valid ground for judicial recusal, provided there is credible evidence to substantiate the allegation. Judicial impartiality is a cornerstone of the legal system, and any appearance of bias or conflict of interest undermines performance in judiciary. In Kenya, the principle, that is point number two. In point number three, in Kenya, the principle that justice shall not be done but also seem to be done is well established. For example, in the case of Rai and three others versus Rai and four others, petition 4 of 2012, the Supreme Court of Kenya emphasized the importance of impartiality and the need for judges to excuse themselves where there is real possibility of bias. Similarly, the test of apparent bias is where a fair-minded and informed observer would perceive a real possibility of bias. So, however, mere allegation without evidence are sufficient to warrant recusal. In cases like Bail UK Limited versus BFL Properties 2000, the court held that suspicions must be objectively justified. The burden of proof lies to the party making the claim, and the evidence must demonstrate actual bias or responsibility of biasness. Point number 5. In this scenario, facts of the question, if claim of bribery is supported by credible evidence, it will form the valid basis of the recusal. However, filing such application without evidence would be considered a piece of the process and might attract legal consequences. It is crucial to approach such matters with caution and integrity. The case law in Chitembwa versus the tribunal appointed to investigate the conduct of Honorable Juma Chitembwa, Judge of the High Court, petition E001 of 2023, the Supreme Court judgment delivered on 28 December 2023, the Supreme Court affirmed the decision of the tribunal that recommended the removal of Justice Sage Chitembwa from judicial service. Is a common case. One can quote the tribunal have found the judge, amongst other grounds, lack of integrity by engaging parties who are litigant before him outside court setting, contrary to Article 10, 73 to 75C of the Constitution, as well as Regulation 11, 3A, B, 13, 3, 2021, and 30 of Judicial Conduct and Ethics 2020. So that was a question with many marks. You explained that. We go to question 2. Susie Advocate is a sole proprietor who runs the firm Susie and Company Advocate, one of the most esteemed clients, Miss Richie Antivibes. She's a real business, estate business. She pays him Kenya cedis 250,000 on a monthly basis just in case she needs some legal work. He is being paid to date. Susie has been instructed by Miss Richie Antivibes to purchase a property on her behalf. In the meantime, Susie has been getting massive amounts of work. Has found it prudent to take the partner, Advocate Snoopy. He has been changed his law firm name to reflect his status. The law firm is now Susie and Snoopy Company Advocates. Being quite busy, he has forgotten to inform Miss Richie Vibes that he has changed the name of the law firm. However, he introduces Snoopy to Miss Richie Vibes. He informs her that as henceforth Snoopy will take over all matters pending in the law firm. Miss Richie Vibes are not object. Snoopy takes over all the matters pending in the law firm. Miss Richie Vibes does not object. Snoopy takes over the purchase of the property. Purchase of the property that Frinzi has commenced on behalf of Ms. Richie Vibes with a probe. He drafts all the requisite conveyancing documents, communicates daily with the Ms. Richie Vibes on the status of the transaction. He even attends court for mediation on the property at some point. Finally, Hula success. The land is transferred and title deed issued to Ms. Richie Vibes. Sweepy and Snoopy has filed a bill, of course, as they wait the ruling on this matter. Ms. Richie Vibes have made an application that's stranger to the bill, of course, filed by Sweepy and Sweetie. Sweezy and Soupy, co-advocates. She claims she instructed Soupy and company advocates. She is emphatic that she never had an agreement with Susie and Snoopy Company from them to do any legal work on their behalf. She is adamant that she cannot and will not pay the fees. With aid of relevant case law, discuss the ethical issues arising from the scenario. So was one of the most difficult question in these exams. This is a question, if I was doing this paper, I could have avoided. The question has never been tested since 2008. Ten marks, you give 10 points. And you must quote a case law. Yeah. So there was a similar case like this one that had the same facts. It was called Omulele and Tolo Advocates versus Mott Holdings Limited 2016. Which I want to project. And from this case, we can draw our answer. So that is the case on the screen. It was a Court of Appeal decision. Yeah. Omulele Tolo Advocates versus Mount Holdings Limited. So the facts of the case, by a written agreement between Majid, the third party, the law firm known as Mulele, firm engaged the latter as lawyers to defend Mombasa. In addition to this assertion, the third party has engaged the appearance of the two suits, namely, which involve the third party, two other subsidiary. Yeah. I'm going to jump number one, paragraph number one. Meanwhile, in course of the operation, the applicant brought a new partner and henceforth came to be known as Omulele and Tolo Advocates. The applicant, in other said that they continue serving the respondent in the same manner as before. Therefore, thereafter, but prior to the determination of asset suit, the relationship between the applicant and the third party was leading to termination of the oral agreements. According to applicant, this was related to that party's failure to remit monthly dues as earlier agreed. In bid to realize the payment of fees, the applicant moved to the High Court to do the three separate miscellaneous applications, which these advocates can be, of course, dated their file. The taxation bill, of course, was contested. So, yeah, so the case has a similar facts as from with this case. So this would have been my argument for this question. Answer to this question, number one. So the resolution of this dispute turns to the definition of two concepts, a retainer and a retainer agreement. So, according to Brack's law, dictionary point number two, deriving from the judgment of this case, a retainer is defined as grant authorization for a lawyer to act in the case, a fee that client pays to a lawyer simply by available when the client needs help, a lump sum fee paid by client to engage a lawyer and asset of the matter as term as engagement fee, an advance payment of fees to work the lawyer will perform in future, also termed as retaining fee. So that is a retainer. In Husband's Law of England, fifth edition, at paragraph 13, at page 13, paragraph 73, the concept is defined thus: the act of authorizing or employing a solicitor to act on behalf of a client constitutes a solicitor retainer by that client. This gives the retainer equivalent of making a contract for solicitor's employment. From the above definitions, retainer covers a broad spectrum. It encompasses the instruction given to advocates as well as fees paid thereafter. A retainer does need to be written. It can be oral and even be inferred from the conduct of parties. However, if no evidence of retainer except a statement from the advocate which can't contradicts, the court will treat the advocate as having acted without authority. On the other hand, the term retainer agreement is anchored in Advocates Act, particular section 45. Therefore, it provides that agreements with respect to remuneration, so subject to section 40, whether under enforced under section 44, before and after in course of contentious business made an agreement fixed on the amount of the advocate's remuneration, therefore, before, after, or in course of contentious business in civil case, make an agreement fixing the amount of advocate's action fee in respect, therefore, of his fees appearing in court paper, and such agreement shall be valid and bidding on the parties provided in writing signed by the client in his. So that is the definition of section 45 on retainer. An agreement entered into person to the above section is what we call term retainer agreement. As section indicates that such agreements parties must fix and put a cap on advocate's action fee, meaning that both parties are beholden to the amount so fixed. From the foregoing, it should thus be clear in the presence of a retainer is what it gives to the retainer agreement. In other words, only when engagement and terms thereof have been agreed upon and can be reduced into writing. It also follows that the retainer agreement to be valid and binding, the same must be put in writing, signed by client or his agent. So that is point number what? 1, 2, 3, 4. Fifth point, under section 45.5, an advocate is party to a retainer agreement and who has acted diligent for client is entitled to sue for recover for the whole retainer fee should his client default in payment thereof. In fact, as long as the advocate has been diligent, his entitlement to fixed sum is so outright that need not to tax his cost nor gives to certain notice to grant prior to pursuant to the said day. Consequently, to behold such advocate to ensure that retainer agreement once made is reduced into writing. Point number 6, the same owner's proof applies to a retainer. As earlier, where client disowned an oral retainer or even existence of a retainer relation, it's for the advocate who claims under retainer to prove the court that such relationship indeed existed. Otherwise, the court will deem that he had acted without instruction. In this case, now like the facts of the case, it's common ground that no written but oral agreement regarding the detention and payment or apparent fee by the respondent. There was therefore no retainer agreement as envisaged in section 45 of the Advocate Act, but a retainer. It also common ground that the applicant have been duly instructed to act for the respondent, and in so acting used to be paid monthly fees as remuneration as evidenced by the question. The trial court appreciated as much and went to hold that it did so in my view that despite the change of farm name, those instructions continued to subsist until when the respondents changed advocates. So having established that parties was based on a retainer and not a retainer agreement, what remedies are available parties should the retainer relationship breakdown? According to Haspari Rules of England, 5th edition, at paragraph 14, at page 14, paragraph 64, when an oral retainer exists or whether a relationship is implied, the relationship thus created is a fiduciary one, which an advocate being the agent and the client the principal. As a result, the party rights of the obligation fall within the realm of role of agency. Uh-huh. Now we have entered the role of agency. Implied authority and stateful authority. Uh-huh. Although Miss Rich Vibes insists he did not instruct the new firm, her conduct accepting legal services from Snoopy, communicating with him and letting him act on court of behalf could amount to acquiescence of implied consent. Doctrine of holding out. When a client through action permits or allows a person to act on their behalf, an adjacent relationship can be implied. Case law in Freeman Locke versus Backhurst Park Properties Magal 1964 2 Queen's Bench for it. It was said that a principal can be bound by the acts of agent where the principal had represented or ordered to be represented that the agent had authority. Application Miss Rich avoids accepting services from Snoopy without objection and even allowed him to appear in court for her. This can support a finding of ostensible authority, and thus she may not be able to later claim that she's stranger to the law firm that rendered those services. Mhm. Section 44 of the Advocates mandate the Chief Justice to make rules on the elimination of advocates. These rules gain automatic application when an advocate is engaged in an unwritten agreement with the client, namely a retainer relationship, subject to the fees fixed by Chief Justice. The advocate then complies with his advocate client bill of costs and present the same for taxation before the tax master if there is dispute on how much fee should be paid. In conclusion, the bill of costs filed by law firm will be enforceable against Ms. Rich Anti Vibes as taxed by the tax master, and her application will be dismissed. So that is the answer to that question. A very difficult question indeed for ATP student. Yeah. So we continue. Question 3. So question 3. A. Having completed the advocacy training program, subsequently be admitted to the Kenyan Bar. You are keen on setting up a legal practice. You are aware that one of the regulatory requirements is maintaining a client's bank account, which you proceed to open upon registration of the firm. Making reference to the source of the regulatory requirement, highlight the types of funds that must be deposited or keep the client's bank account. Uh-huh. So the key word there is source of regulatory requirement, highlight the type of funds that you deposit or keep in the client's bank account. Question asking candidates knowledge on client's account, 5 marks, you give 5 points. Question never tested before since 2008. So what is the regulatory requirement? Advocates Account Rules 1966. So what are the types of funds? Type of funds to be kept. Rule 5 is relevant of the Advocates Account Rules 1966, which says they are to be paid into client's account. So number 1, trust money. Such money belonging to advocates as may be desperate for maintaining the account. C. Money to replace any sum drawn from the account in contravention of these rules. And a check or draft received by advocates which under Rule 6 is intended to split, but which he or she does not split. B. Question 3B. Having set up the firm and commenced legal practice, you encounter a problematic client, one Anakombe, who refuses to pay legal fees and expenses for disbursement. You have already instituted suit in court on his behalf. You are keen on ceasing to legal representation of the client. Citing any applicable regulatory requirement, explain how you cease from representing the client in the court matter. So this is a miscellaneous question, which I call a miscellaneous question. not necessarily a professional ethics question, but a civil litigation question. 2 marks, you give 2 points, and your answer should not be confused with C, C below. So, question required a candidate to discuss change of advocate to be effected by order of court or consent of parties, Order 9, Rule 9, Civil Procedure 2010. So that is the regulatory requirement. So how we use this from representing the client. So Order 9, Rule 9 says where is a change of advocate or party decide to act, person having previously engaged an advocate after judgment have been passed, such change or intention to act in person shall not be affected without the order of the court. So there must be order of the court. That's the point number one. Upon an application with notice to all parties or upon a consent. So there must either an order of court or a consent between outgoing or incoming advocate or the person intending to act in person. So those are the 2 points, 2 marks. Based on the regulatory requirements, highlight the specific requirements that have to be satisfied for you to be considered to have effectively ceased legal representation of the incumbent in the suit. Again, a miscellaneous question, not necessarily professional ethics question, but a civil litigation question. 3 marks, you give 3 points, not to be confused with question B above. So remember previously in the previous videos, I have said that every time you are given a question, read all the parts and or sub question, and be sure that you don't answer an answer for part B or to C. So you must know that differentiation even before you start answering. So question required the candidate to discuss Order 9 Rule 13. So that is the specific requirement. So it says when an advocate who have acted for a party in course of the matter have ceased to act and the party has not given notice to change accordance with the order, the advocate may on notice be served on the party personally or be prepaid postal letter addressed to this road press unless the court otherwise directs. Apply by court in Chamber 7 for an order to effect that advocate have ceased to be advocate acting for the party in the case, and the court may make order accordingly, provided that until the advocate has. So what is effective ceased representation? On top of applying for a court order, which was answer for B, then the 3 points are from A, served every party. So you must serve every party the order, have they procured the order to be entered in the appropriate court. Then point left at said court a certificate signed by him and order have been duly served, and he shall subject to this be considered to the advocate to the party final conclusion of the order. So serve on the every party, number one, the order. B, procure the order to be entered in appropriate court. So that court must, the order must be entered in the appropriate court. And left the said court a certificate signed by him that the order have been duly served as oversight. Yeah. So two, order one, rule one, rule 13 2 says, from and after the time when the order has been entered in the appropriate court, any document may be served on the party to whom the order relates by being filed in the appropriate court, unless until that party either appoints another advocate or else gives such address is required for the party acting person and also complies with the order related to notice of appointed or advocate or notice to intention. So the 3 points were in one order 9, 13, 1, A, B, and C. So that was the answer. So I go to question 4. Richard, an advocate, was instructed by Octopus Limited to cease certain proceeding against the Council for Higher Education in relation to 3 examination scrutiny apparatus that were supplied but not paid. It was agreed between Mr. Richard and the managing director of Octopus that the instruction fee would be upon issuance of instruction letter. Later, the managing director of Octopus Limited wrote to Mr. Richard informing that one Mr. Daud, who is not related to Kama, agreed to pay the instruction and overheads of the litigation. Underline that. The managing director of Octopus Limited told Mr. Richard that the conclusion of the case, Mr. Richard would be required to pay the detrimental sum to Mr. Daud to enable him to deduct the instruction fee and other overheads incurred during the litigation. Underline that. In the meanwhile, before any disbursement is made, Mr. Daud intimates to Mr. Richard that they would also wish that there were any dispute to occur in respect to agreed arrangement. Mr. Richard will represent Mr. Daud. Underline that. Moreover, the Council for Higher Education approached Mr. Richard, seeking to give him a retainer for 1 year to act as his advocate. Underline that. So 4A, initially the managing director of Octopus had requested Mr. Richard to file an application seeking to right to sue as a pauper. Why would you advise against such an initiative? 3 marks, give 3 points. So this again is a miscellaneous question and necessarily a professional ethics question, but a civil litigation question. 3 marks, you give 3 points. Never tested before since 2008. Related to question 3, to this question in question 3BC, November 2023, which was asking about proper beliefs in criminal trials and dispeppering. You can look at that. So the answer is found in order 33 rule 1 on suits which be instituted by a pauper. So subject to the following rules, any suit may be stated by a pauper for this purpose or another person. A pauper, when it's not possessed of its sufficient means to enable pay the fees prescribed by the law at the institution of such suit. So the definition of pauper order 1, rule 1, 2, or pauper is not possessed of sufficient means. So remember, Octopus Limited is a company. It may not be, is not may usually applied to natural persons and people with no sufficient means to pay legal fees. So that is point number 1. Why would you advise against such an initiative? So it is usually on natural people and people with no means, but it seems that Octopus is a company and they are people with means. So the next point number 2, order 33 rule 10, where the so order 33 rule 2, contents of the application. Every application for permission to sue a pauper shall contain particulars required in regard pleadings together with a statement that the pauper is unable to pay fees prescribed in such suit, and the whole shall be signed in the manner prescribed by signing of the pleadings. So under that rule 33 rule 2, you can say there will be an examination of the proper application by court, which will be rigorous and most likely Octopus will not succeed, so that way they will be wasting their judicial time. and their nini, even the fees they are going to pay the advocates. Order 33 rule 10, point number 3, cost of pauper when it succeed. So when a pauper succeeds, such amount which he ought to have paid as court fees are recoverable by court for any party ordered by decree and shall be first charge of a subject matter. So the cost is usually recovered from the other party if they win the case. So that means that the amount that they are going to receive if they win the decree, the case is going to be reduced. Yeah, to recover the cost that they to have paid. So question number B, before any disbursement is made, Mr. Richard seeks your opinion whether he's conflicted in this matter. Explain how conflict of interest arises and whether there is existing conflict of interest arising at this stage. So remember in my previous videos, I've said that conflict of interest and confidentiality is a compulsory question in every exams. So know all the law that revolve around that, and you'll be in a good place. And this question is usually tested in every paper. Conflict of interest where an advocate duty to one client is compromised. So this is the answer. Conflict of interest arises when one advocate's duty to one client is compromised by their obligation to another client, a third party or their own interest. This principle is central in maintaining professional integrity and ensuring impartiality in legal representation. In Richard's case, there are several potential conflicts of interest. The presentation of Mr. Daud. Mr. Daoud is not directly related to Octopus, has agreed to pay instruction fee and overheads. He also expressed a desire for Mr. Richard to represent him in any dispute arising from the arrangement. This creates a potential conflict because Mr. Richard to Octopus might be impressed by financial reliance on Mr. Daoud. Payment of decretor sum. The arrangement where Mr. Richard is required to pay the decremental sum to Mr. Daoud for deduction introduces a financial entanglement. This could compromise Mr. Richard's ability to act solely in the best interest of Octopus Limited. Then finally, retainer from Council for Higher Education. The Council for Higher Education, which is the opposing party in the litigation, has approached Mr. Richard for a retainer. Accepting the retainer will create a direct conflict of interest as Mr. Richard cannot represent both sides of the same related matter. Uh-huh. So at this stage, there is already a potential conflict of interest due to the financial arrangement with Mr. Daoud and his request for representation. Additionally, the offer by Council for Higher Education present a clear conflict. Mr. Richard should be careful evaluate this situation and consider declining the retainer from Council for Higher Education to avoid compromising his professional obligation. He should also ensure that his relationship with Mr. Daoud does not interfere with his duty to act in the best interest of Octopus Limited. Uh-huh. D, question 4D. Between Octopus Limited and Mr. Daoud, to which entity will Mr. Richard owe a professional duty as an advocate? 2 marks, you give 2 points. Question never tested before. Examine, sorry. So we go to C first. 4C. Examine the obligation Mr. Richard has toward Octopus and Mr. Daoud given the principles set out in the case of Sobeth Development Limited versus Nyanza Sugar Limited Company Limited. Mhm. So 2 marks, you give 2 points. So in this is not the answer to the question, but in Sobeth Developers Limited versus South Nyanza Sugar Company Limited 2010, Kera, the High Court addressed issues concerning conflict of interest of arbitrator impartiality. The applicants of the sought to set aside an arbitration award on the grounds that the arbitrator, Justice Akiumi, had undisclosed relationship with the respondent counsel, especially the arbitrator's son had previously employed by the respondent law firm. The same firm had represented the arbitrator and his wife in property transaction. The firm had acted for the arbitrator's daughter in legal matters. The court found that the arbitrator failed to disclose this relationship, which could lead to perception of bias. Emphasizing the importance of transparency, the court stated that even appearance of partiality undermines the confidence of the arbitration process. Consequently, the court set aside the arbitration alert, highlighting that the disclosure of the potential conflict of interest by an arbitrator constituted a misconduct. So I have just discussed the case just in case it comes in the exams. So what is the obligation uh, to, uh, to Octopus, the client? So Mr. Richard primary professional duty is to Octopus Limited as they are the client instructing him on the matter against Council of Higher Education. The arrangement that the determined sum will be paid to Mr. Daud to recoup fees and overhead is highly irregular. Advocates are expected to account directly to the account, note that patent annex express intent instruction and clear legal grounds exist. Around Mr. Daud, an party to interfere in disbursement may compromise Richard's duty of loyalty and his parents in this case. Obligation to Mr. Daud, the financial. Mr. Daud is essentially a third-party funder. Mr. Richard owes him no fiduciary unless a separate clear construction relationship exists. Agree to represent Mr. Daud in potential dispute related to the same matter would amount to conflict of interest. He cannot represent two parties with potential diverging interests arising from the same case. Potential retainer with counsel for higher education. The opponent, the counsel is the adverse party in ongoing matter. Accepting a retainer from the counsel while acting against them is clear and acceptable conflict of interest. It violates the principle of undivided loyalty to account and could lead to professional misconduct charges. Question 4D. Between Octopus Limited and Mr. Daud, which entity will Mr. Richard or a professional duty as an advocate? Explain. Yeah, so the answer is to Octopus Limited because is the one who has hired them, is the client who have instructed them, and Mr. Daud is just a third party funder, and they don't know owe him a professional duty as an advocate. Question never tested before. Question 5. So question D of 4D, you could have used some of the answers from C and answer it. So I got to question 5. So Amaro is newly admitted advocate. He has a disagreement with has landed because she has been demanding an increment in rent in what he considered to be unforgiving economy. When he refused to accede to her demands, she kicked him out other than seriously. He came home tired as a dog from tedious day of litigation and found all belongings to a cab at the gate. He was livid. He sued her next day. He decided to represent himself. underlined that surely all this hard work at Kenya School of Law should count for something. He reasoned to himself. Indeed, it did, because he won his case. The bill, of course, is currently in court for taxation, underlined that. However, this landlady is consenting the bill on item of instruction claimed by Wamalo, underlined that. In the meantime, it has emerged that the lady who is a caterer did not pay her own advocate's fees because he agreed between them that she would either pay if she was successful or not. Pay in kind, rendering her catering service to her advocate for a week. Underline that. Question 5a. From the vast knowledge of professional ethics and practice, advise Wamalo on the item claim on instruction fee. So first time the question was tested since 2008. 3 marks, you give 3 points. So instruction fee are advocates earn for taking on matter and preparing for hearing. In Kenya, they are guided from Advocates Remuneration Order, the Advocates Act, President from Kenya's case law, taxation principles applied by taxing officers in court. Instruction fees are not strictly pegged on actual hours worked on actual sum recovered in case rather than the excess based on the value of the subject matter, its the importance and complexity of the case, the nature of extent of work, the interests of parties, and the conduct of the proceedings. Wamalwa is entitled to claim instruction fee even if he represented himself, as long as he acted in the capacity as an advocate and not as a lay person, a lay litigant. So while lay persons representing themselves cannot recover legal fees, advocates representing themselves can. But there is a catch. So there are two case law to note. Joreth Limited vs. Kegano and Associate 2002. The Court of Appeal held that instruction fee are meant to compensate an advocate for work done regardless of actual amount recovered and should consider the nature and complexity of the matter. Another case, Kipiri, Tito and Kiara Advocates versus Deposit Protection Fund Board 2005. Self-representation by advocate does not discriminate them from claiming legal fees, but must be justifiable, reasonable, and not exaggerated. So Mamara must justify the fee claimed with reference to complexity of the case, time and effort expended, precedents on reasonable fees from similar dispute, especially on landlord and tenant cases. B. What is the rationale of having bill of cost taxed? So 2 marks, you give 2 points. Question never tested since 2008. The ethical rationale for having a bill of cost tax in court in Kenya lies in ensuring fairness, transparency, and accountable in the legal profession. Taxation, of course, is a process designed to prevent overcharging by advocates and protect clients from excessive legal fees. It also ensures advocates are fairly compensated for their work for fostering trust in the legal system. So the relevant law governing the process is Advocate Act and Advocates Remuneration Order, Specially Advocate Section 48 of Advocates Act, Section 51, and Advocate Remuneration Order. By subjecting the bill of cost to taxation, the court ensures that the fees charged are reasonable and then with line with the work done, the complexity of the case, and applicable legal guidelines. This process supports ethical standard of the legal profession and promotes justice both advocates and clients. What are the ethical issues arising from argument between the landlady and the advocate? 5 marks, you give 5 points. Question never tested since 2008. Contingency fee agreement. The landlady agreement to pay her advocate only if she won the case amounts to a contingency fee agreement. Why is it problematic? Contingency fee agreements are generally prohibited in Kenya unless specially allowed by statutes. So, yeah, contingency fee are generally prohibited in Kenya. Rule 9 of advocate practice rules talk about, and in the past paper we have talked about contingency. Payment in kind, lack of transparency and violation issues. Point number 2, the landlady agreed to pay with catering services as a payment in kind and in which she lost the case. Why is it ethically concerning? There is no clear evaluation of services rendered versus services received. This raises the issues under advocate account rules. All fees, whether received due, should be accounted for ideally in monetary terms. Accepting non-monetary compensation may lead to unethical conduct if the value is not established. So potential conflict of interest and professional independence. Point number 3, an advocate who depends on success outcome of the for remuneration or services may be tempted to take an ethical shortcut, compromise the legal advice to suit the client desires, lose professional and integrity. This undermines the integrity of legal profession and amount to misconduct under SOPEC. Breach of fiduciary duty. Point number 4, the advocate has a fiduciary duty to act in the best interest of the client within the law, not based on personal gain or reward of the outcome. Entering into an agreement contingent on the success and payment in kind should be seen as exploiting the client, the issue of failing to properly advise of the risks of such agreement. Professional integrity. Point number 5, advocates are expected to maintain high standards of integrity. Honesty, integrity rules are very important in SOPEC. Always remember them, because also you must be asked about honesty and integrity in question. Accepting payment in kind, especially in a manner contingent outcomes, could be perceived as undermining the profession of legal practice. So those are 5 points. Give 5 marks. So the last question, question 6. 6A, despite categorizing legal career as profession other than mere a business, Tom Ojenda and Katrina Juma nonetheless emphasize that advocates client relationship is based on contract. So underline that, which also in case with other business ventures. Tom Ojenda and Katrina, Professional Ethics and a Kenyan Perspective, Raw Africa, Nairobi 2019, page 13. So discuss the context in which legal career amounts to contractual obligations similar to other business ventures. So 3 points, you give 3 marks. Question never tested before, but not a very difficult career which fundamentally a profession involves contractual obligation akin to other business ventures due to the nature of advocate-client relationship. Here is the context which this marriage arises. So point number 1, formation of advocate-client relationship. The relationship is established through a contract, whether the written or implied. This contract outlines the terms of engagement, including the scope of legal fees and obligation of both parties. Provision of services. Point number 2, advocate provides legal services in exchange of remuneration, similar to how business offer goods and services for payment. Fee agreement. Advocate act and advocate remuneration now govern the fees charged by advocates. These fees are negotiated and agreed upon effecting a business-like transaction. Despite disputes over fees such as segregation of costs, further highlight the contractual nature of the relationship. Point number 4, accountability and performance. Advocates are accountable for their clients for quality of their services, just as businesses are accountable to their customer. Breach of contract, whether through negligence or failure to deliver agreed services, can lead to legal consequences. So, point number 5, ethical and professional standards. Where advocate current relationship with contractor is governed by ethical standards that distinguish from ordinary business ventures. Advocates must prioritize their client interests, maintain confidentiality, and uphold the integrity of the profession. So analyze the extent to which legal practice departs from the principle of freedom of contract through the concept of invalid agreements and thus corresponds to the professional code of aspect rather than business venture model. So that is question 6A2. These are repeated question that's tested in question 6A, November 2023. Question required candidate to discuss section 46 of the Advocates Act. There are 4 or 5 points on invalid agreements. I projected and discussed at question 6A, November 2023. So I don't need to do it again. So among the foremost professional owners, question 6B, the last question of the day of this paper, among the foremost professional owners that Kenya's legal practitioners aspire to have their name entered in the role of senior counsels. Explain the professional practice norms of privilege of this designated senior counsel in context of litigation in courts. 3 marks, you give 3 points. Question never tested before since 2008, and question required a candidate to discuss the Advocate Senior Counsel Conferment and Privileges Rules, Rule 19. Yeah. So, yeah. So what does it say? I think I can project. So duties, powers, and privileges of a senior counsel. So the question is asking you on what? Norms or privileges in context of litigation. So point number 1 is president is having his matter mentioned when appearing in court or tribunal. Point number 2, when appearing robed in court or tribunal or wearing the gown and the court sleeved waistcoat as worn by judge of the Court of Appeal. The exclusive right to sit within bar in all courts in which there is a bar separating the area of senior counsel from the general of the area of the court. In other courts, to sit on the front bench. Yeah. So you are required to discuss section 19 of Advocates Senior Counsel. The Advocate Senior Counsel Conferment of Privilege Rules 2011, Rule 19. So we have come to the end of the paper. The paper was not easy. Many new questions. And it may be justified why there was it was the most failed paper. So read widely. Advocates professional ethics and practice is a very wide and theoretical subject. All the best in your exams. God bless you. Subscribe to the channel and tell others. All the best.